All set? Okay, good morning and welcome to the October 11th, 2018 meeting of the New York City Campaign Finance Board. The first order of business is the approval of minutes from September 13, 2018. I'll move the approval of those minutes. Is there a second?
Second.
All those in favor?
Aye.
Aye. Opposed? Abstentions? The motion carries. The next item of business is my report. Election Day 2018 is less than 4 weeks away. All New Yorkers should make sure that they are ready to vote by checking their voter registration status and registering to vote today. Tomorrow is the deadline to submit a registration form if you wish to be on the voter rolls on November 6th. Visit voting.nyc and click on voter registration to learn more. The November ballot will have 3 proposals for city voters to decide, including a proposal to significantly strengthen the public matching funds program that this board administers. I urge all New York City voters to watch out for the voter guide to learn more about these proposals. Guides will arrive in your mail later this month, and the CFB's online voter guide will be going live at the beginning of next week. Some of you may have read an op-ed last week in the New York Post that was highly critical of campaign financing. Our executive director, Amy Lopres, sent a letter to the editor of the Post responding to that piece last week, and I would like to read it to you now. And here's Amy's letter. Stephen Eide repeats an argument we often hear from opponents of campaign finance reform, that politicians are corrupt and there is nothing to do about it. Thankfully, while Americans may be troubled by the current state of our politics, there is increasing evidence that they are not nearly so cynical as to buy that argument. Voters in cities across the country have adopted public financing in recent years as a way of encouraging good people to run for office. The facts are clear. New York City's public financing program has produced elections that are more competitive and that are open to a more diverse pool of candidates. There is one point where we agree with Mr. Eide. Raising money is one way serious candidates can distinguish themselves from frivolous ones. How candidates raise their money, however, matters. Many small contributions from individual New Yorkers better demonstrate a candidate's seriousness than a few huge checks from special interests. If we want to hold our elected officials to a higher standard, shouldn't we start by holding them to a higher standard when funding their campaigns? To us, this sounds like a great idea. And that's the end of Amy's letter. I'll now turn to its author, Amy, for her report.
I don't have very much. I just want to also remind everybody who's listening that October 12th deadline for registering is also the deadline to enroll in a party or change your party registration for next year. New York State is the only state that requires you to register in a party more than a year before the election. So if you are registered not in a party and want to change your party, you need to do that by Friday. Last week, we held our bi-monthly Voter Assistance Advisory Committee meeting, and since the chair of that committee is not here today, I'll just talk a little bit about what happened. We heard from 2 organizations that are doing very interesting work in trying to engage people to go out and vote in different ways. The New York Civic Engagement Table and sorry, the name of the other organization just went out of my head. I'm so sorry about that. But it's online, all the testimony, but a group of Wagner graduate students who organized a platform to gamify the voting process. Also last week, Eric Friedman, our Assistant Executive Director for Public Affairs, testified before the City Council on a package of bills aimed at encouraging and the Department of Corrections and the Department of Probation to give more information to their client base about how to vote and how to register to vote. So we have been doing that work with our voter assistance team for many years under Local Law 29, but this package bills would require both the Department of Corrections and the Department of Probation to be more proactive in engaging those populations.
Thank you. The next item of business is our announcement of campaigns and compliance. You will recall that we started several meetings ago a new tradition that as our post-election audits progress and we identify candidates or campaigns that are in compliance and have no issues, we will announce the names of those campaigns so as perhaps to counter the impression from the vast volume of our business that there seem to be, everybody seems to get penalties, and that's not the case. It's actually a small percentage or minority percentage of those who do. So we want to recognize those who are clean in the audit process and thereby counter, give a full view of the work of this board and of the general level of compliance by candidates, which is quite high. And so the following candidate from the 2017 elections has completed the post-election audit process without any violations or penalties assessed by the Campaign Finance Board. The board recognizes the diligence of the candidates and their campaign staff in running campaigns that maintain compliance with New York City's campaign finance law. And that candidate is Victoria E. Cambranes. Okay, we have two matters involving penalties before the board today, one of which involves a candidate appearance, and that is Mr. Richard Bashner. So if Mr. Bashner would like to have a seat at the table to my right, and our staff attorney take his seat at the table to my left. Mr. Bashner, the way it works is the attorney for the CFB will give a very short statement, basically just laying out maybe some back and forth after that.
Thank you, sir. As a preliminary matter, may I bring something to your attention?
Sure.
When I was I believe, summer associate, I worked for Mr. Davis. Good to see you, Rich.
Nice to see you.
I don't know if that affects anything, but I thought I should disclose that because I ran a clean campaign, and I'm going to continue to act in a clean and honorable manner in everything I
We
undertake.
appreciate that, and it's,
What year was that?
Summer '84.
Okay.
we'll leave the issue of recusal entirely to the discretion and conscience of Mr. Davis. 1984 being what now, almost 35 years.
I don't believe we've had any contact since then.
Maybe a statute of limitation on that particular contact.
But I felt obliged to mention it.
Thank you very much. No, it's very correct and honorable of you to do so. Okay.
Good morning, Chair Schaefer, members of the board, Executive Director Loprest, Mr. Bashner. My name is Joe Gallagher. I'm Associate Counsel for the CFB, and appearing with me today is Celia Liang, an auditor for the CFB. Before the board today is the matter of the Richard Bashner campaign in the 2017 election for mayor. The campaign was a participant in the program and did not receive public funds. And CFB staff recommends that the board find the campaign committed one violation of the Acton Board rules in accepting contributions over the limit. The campaign contests this violation and associated penalty.
Okay, thank you. So the issue has been teed up, and Mr. Bashner, the floor is yours.
Well, thank you for the opportunity to, can you hear me clearly? Okay. Thank you for the opportunity to speak today. I want to just begin by saying that anything that I'm going to say about the board, I'm not here to quarrel with the board. I just want to provide context for how my campaign unfolded. And I really appreciate the opportunity to put some color and life into the dry papers that I submitted. Briefly, you may be curious why I ran for mayor against a mayor who received matching money, millions of dollars, and clearly we were all overmatched. I've been a member of my community board this is my 20th year now, and a basketball and baseball coach for 13 years for my children and other people's children. And I care deeply about the city. I was born in the Bronx. I've lived here all my life except for 4 years in college. And I came back to NYU Law School. I volunteered for the then deputy mayor to, try to help if I could. And I've been a lawyer in private practice for these many years at a firm, same firm since 1994. And in the summer of 2016, frankly, I was distressed about the direction of the city, and I thought that the most vulnerable New Yorkers needed someone to speak up for them a little bit more. My daughter is fortunate to attend a public school, Bard High School Early College, which is terrific. They have PhD professors teaching them. But most of the kids don't. And where I grew up in the Bronx, those schools are still languishing. Our seniors are not sufficiently taken care of. My dad had multiple sclerosis, and our disabled people are not sufficiently taken care of. And I thought someone needed to speak up. And criminal justice reform, and I could go on, but I won't because it's not the right venue for that. At any rate, in the summer of 2016, I looked at the rules that were then in effect for the coming 2017 election, and I thought that we needed a vigorous debate about the direction of the city. And I saw that the rule was that if you raised $50,000, that you would be able to participate in the debate. And I started to make plans to enter the election unless someone else had jumped in who I felt could forcefully advocate for all the things that I believed in. And as the months passed, no one else did who I thought was effectively making the case. And it took some time to put a campaign together, and I wound up entering very late on May 11th. And I was able to raise approximately $50,000 in the first filing cycle by July. And in fact, the initial reception I got in speaking at clubs, I went and spoke to the Brooklyn Independent Neighborhood Democrats. And after their straw poll, I got 20% compared to the mayor. And Al Albanese got 5%. And I thought, this is worth proceeding with. And that was before I had lent the campaign money and before I had gone ahead. And as I made my calls, people were very supportive. They said, we're really proud of you for standing up for all of this, and especially in the age of Trump, after Trump had won at that point, that it was important to help move the needle on public policy, federally, locally, across the board. Campaigns are not inexpensive. And I made some startup loans. I made $40,000 in startup loans, which didn't seem to me to be an extraordinary amount for a mayoral campaign when Mayor Bloomberg had spent $250 million on his 3 campaigns, and Mayor de Blasio had gotten matching money. I made a loan of $40,000, and I can tell you, and my wife, if she were here, would tell you that I fully expected to get repaid that money. At no point did I plan to make a contribution of $40,000. I was willing to put in the $15,000 approximately, but not $55,000. Well, then what happened? We continued along, and my reception everywhere was very positive, and I raised as much money as I could. But then the debates came along, and the first debate, as you know, is 90 minutes, and the second debate is 60 minutes. And the reason the first debate is 90 minutes because it's contemplated that there will be multiple debaters. And instead, because the rule had been changed in December, 9 months before the election, to require $175,000 in fundraising, it raised the bar, and I wasn't able to raise that much. Maybe if I had started earlier, I don't know. But at any rate, the decision then was, do you drop out and drop out of the public financing system? And I thought, no, I'm here to make a point. And if I get fined, well, I'll have to get fined. And what can I do? I'll just keep trying to raise money. And, the sad thing is that once you're not in the debate, as far as the public is concerned, the election's over for you. Now, they'll still listen, and they did listen, and I went on to a series of additional debates, and I, created a vigorous website that got a lot of play and many hits. And I'm really proud of the campaign I ran. I was a first-time candidate, and I ran for mayor of New York, and I got over 11,000 votes in a 4-month campaign, which was really worthwhile, I think. I'd like to think that it was. And I tried to withdraw from the campaign finance system on the day of the election to avoid a penalty, as the papers say. But it's too late at that point. And so it's a bit of a trap for the candidate. I'm not saying it's anyone's fault. And I could have withdrawn, yes. But when I get to the end of this, and if you don't agree with any of my arguments about why a penalty shouldn't be imposed at all, I certainly would appreciate any mercy that you can give me under the circumstances. So getting down to the specific arguments, the first one was that under CFB Rule 1-03 G5 and 6, forgiven or settled debts do not constitute a contribution if the debt was settled by the creditor in a commercially reasonable manner. I just want to point out also that there are no other violations of my campaign, and I really wanted to thank my campaign treasurer, Martin Golden, who was also a first-time treasurer, has never done this before. And we ran a clean campaign, and we did everything right. And I also wanted to thank Joe Gallagher for his kindness in explaining about the process to me, which is not necessarily everyone does, and something everyone does in an adversary proceeding, which unfortunately this is, I guess. And I should also say, although I'm a lawyer, I'm not a litigator, so forgive me if I don't do this the way a lawyer would. I certainly wasn't going to pay a lawyer to come here today. At any rate, forgiven or settled debts do not constitute a contribution if the debt was settled by the creditor in a commercially reasonable manner. And what that means, according to subparagraph 6, is that the creditor has pursued its remedies in the same manner as that employed by creditors of other debtors, including the institution of lawsuits. Now, what would be a commercially reasonable effort to satisfy an outstanding debt when a campaign has nothing except for $1,500 left over? Well, you can buy the assets of the campaign, and you can accept whatever cash it has. And that's what we did. And so there was an asset purchase agreement, and we accepted the $1,500 as partial repayment and all of the assets of the campaign. Now, in the response that I've received, it says that it glides over this a little bit and conflates a commercially reasonable manner with a commercially reasonable transaction. Now, it doesn't say commercially reasonable transaction under CFB Rule 103 G5 and 6. It says a commercially reasonable manner. And as bankruptcy lawyers will tell you, when a debtor has no money, all you can do is take whatever money they have and whatever assets they have. And it also conflates the campaign's asset with my asset. So as far as I can tell, without being an expert on campaign finance law, it seems to me that all of the assets of the campaign belong to the campaign and not to me personally, and that if I wanted those assets personally on an ongoing basis going forward, that I would have to buy those assets. So I did everything that in a commercially reasonable manner that any other creditor would do to satisfy the debt, which was to accept the $1,500 that was in the campaign's cash and to accept all of the assets. And what were those assets? There's a working website, which is in effect today. You can go and look at it. I'm proud of it. I had a lot of help with it, and I think it's got a lot of things that are useful in it in terms of video, in terms of policy statements, that contrary to what is said in this response, that it would be worthless even to a future Bashner campaign given the passage of time, are all completely relevant. Rikers Island is still open. We still have segregated schools that are underperforming. We still are not taking care of our seniors. We're still not building enough affordable housing. And everything that I said 2 years ago is still relevant. Moreover, in terms of value to a future campaign, if, as I hope and expect, Tish James wins for Attorney General, I'm exploring the possibility of running for public advocate, which would be in February. And it would be quite timely to continue and build off of that website in order to do that. Even if it doesn't have any value in a future campaign, it has value to me personally. And so to say that all of that was paid for already and is essentially worthless, I don't think is fair. I detail in excruciating detail $102,000 plus, $102,000 plus in expenditures that were necessary to get that website and to get the intellectual property of this campaign up and running. And we settled that for a $33,000 debt. Now, if you think the discount is wrong, that it should be discounted more, give me some credit. 15,000, 10,000, 5,000. I think zero is the wrong number, frankly. But none of that is relevant to the point I'm first making here under CFB Rule 103G 5 and 6, which doesn't require a commercially reasonable transaction. To the contrary, it requires that the creditor settle the debt in a commercially reasonable manner. And if I didn't settle it in a commercially reasonable manner, then I ask you, what would have been a commercially reasonable manner? I took all of the assets of the campaign in return for the outstanding debt. So that's on the first point. And actually on the second point, because of the value of the assets and what they might have been worth. The intangible property included the websites, domain names, electronic accounts, Facebook, source code, all of these things. I'm not going to belabor the point. You've got the papers. And in terms of fair market value, the CFB rules actually don't specifically define fair market value for the sale of campaign assets. So I would encourage you to think about that in this context. But it is defined in CFB rules 103G2 and 1310 as follows. It's the charge for services at a commercially reasonable rate prevailing at the time the services were rendered. I'd like to think I paid a commercially reasonable rate, maybe less because I was a first-time candidate, and it cost over $100,000. And in return for debts of $33,000 after deducting the $1,500 in cash, that seemed to me to be a reasonable thing. Again, if I don't get credit for the full $35,000, then some number seems right to me. And I leave it to you to think what that is. I think it's not fair to say that it's worth zero. And again, even if it is worth zero, I settled the debt in a commercially reasonable manner. I'd like to touch on the $1,500, which was not repaid on the day of the election. I did repay a sum, I think it was around $5,000 from the campaign assets, and I left $1,500 on the day of the election. To be fined on that $1,500, it seems to me that we don't want to have candidates who run up debts and don't pay people. And I also think that you have to keep your campaign bank account open for a period of time after the election because there may be debts. So I left $1,500 in. Had I paid back that $1,500 and potentially stiffed people, I wouldn't be fined on the $1,500. So at the very least, I don't think there should be a penalty assessed as to that $1,500. Now, the response here says that I got the benefit of that. The fact is, there were no additional debts because I ran a clean campaign and everybody was paid who needed to be paid in full. And so after a reasonable period, we closed out the bank account, and then I repaid myself that amount as partial payment. And that was it on that. I think that this is a context in which the mayor received millions of dollars in matching money. In his brief for why he deserved the matching money, he didn't even mention my campaign, and I didn't receive any matching money. And I don't want to say no harm, no foul, because I respect the law, and I respect the intention of the law. And the intention of the law, as Mr. Schaefer said earlier, is to increase competitiveness and to give opportunities to candidates who might otherwise not have a chance to be heard. My loans were made in May and June at the very beginning, and I didn't make another loan after that. And I'd like to contrast that with the case that was cited in the opposing papers of Sal Albanese in the previous election, in which he made $100,000 in startup loans, not $55,000. And then during the course of the campaign, he later contributed another $25,000 and another $30,000 for a total of $155,000. In terms of proportionality, although the court case said that he could have been fined for multiple violations, they decided to make it a single violation, and the amount imposed was $10,000. So Mr. Albanese's fine was $10,000 on $155,000, including $55,000 later in the campaign rather than startup loans. That's approximately 6%. If I were fined 6% of the $35,000, my fine would be approximately $2,000, not $9,000. In terms of sending messages to people for the future, it's not a good message to, in effect, penalize someone for their good intentions in trying to follow all the rules, trying to raise money, and then be hampered because effectively, once you're out of the debate, people don't donate money anymore. They say, I didn't see you in the debate. And it makes it very difficult. And at that point, what do? You have to pay the people that you've lined up to pay. You can't not pay your debts. That's not right. And where are you supposed to get the money from? So I didn't make excess contributions. We have a rule here that deems them to be contributions, and I understand the purpose. And you know, I appreciate the help the Campaign Finance Board gave me in shooting a video. I did ask that could I release the video as soon as it was ready, or could I even videotape the video while they were running it on the screen after they shot it so I could use it in my campaign? And they said, no, that's for the week of the election. Well, for the future, if you could help folks before the debate with that, it's going to have more of an impact. So I suggest that to you for future candidates, that if you're going to make the videotaping available, it certainly would be to much greater effect if it were done earlier in the process. In terms of my expectations, again, from the first fundraising cycle, I raised more than any Democrat, including Sal Albanese, in the first reporting cycle, except for the mayor. And based on that, I believe that I would be able to raise enough money to pay myself back. And I did not expect to be on the hook for $35,000 at the end of this campaign. It's not what I plan to do. Now, I know the response of the papers here is that, well, you know, it doesn't have to be an intentional violation. But I also know that the rules specifically say that staff members may, at their discretion, recommend no violation or a violation, no penalty. And that didn't happen here. And that made me sad that I got that response, because I'd like to think that I did a good thing here in trying to open up a debate and respectfully address the critical issues that our city is facing, and that more debate is good. If you don't want people like me to run for office, then penalizing me $9,000 is a really good way to send them a message. I just, in terms of the disproportionality of the penalty, a $35,150 startup loan from a candidate in the context of a mayoral campaign is really very minor. I don't want to minimize the violation, because it is what it is. Although, again, if you settle it in a commercially reasonable manner, there's no violation. And I think that's what happened. But Mayor spent over $7 million, including millions of public funds. Mayor Bloomberg spent $250 million without public funds. I don't think that spending $35,000 extra is something that should be heavily penalized here. $9,000 is a great deal of money. if I had another $9,000 during the campaign, that would have given me an ability to have even more impact than I had. But I didn't want to put in any more money because I didn't think it was the right thing to do. I think that it's also not unfair to let people withdraw from the matching program when they're not getting any matching money. I mean, really, the message here is that you should just fold your tent and go home. You know, it's possible that I could have raised enough money to get in the debate at $175,000 at that point, but it didn't happen. I think I'm repeating myself at this point, and rather than do that, I'd be happy to answer any questions. I guess what it all comes down to is I read the Albanese case closely, and certainly you can find me, and certainly I can't contest it and win. And the question is, should you? Is that what you want to do here today? I mean, is it doing justice to fine me $9,000 for my good faith effort to comply with the law? And of course, I'll abide by whatever your decision is. And of course, my campaign treasurer, my good friend Marty, will not be paying it. It will all be me. And I ask for your mercy in this case.
Okay, let's give the CFB attorney an opportunity to respond if he wishes, and then we'll see if we have any questions from the board.
Thank you. Yeah, I would just say at the outset that in terms of the asset purchase agreement, it was completed past the date of the election. So the violation occurred on the day of the election. So I don't know, the commercially reasonable manner, and that is kind of beside the point that the violation had already occurred on September 12th, and the asset purchase agreement is dated in January of 2018. In terms of the Albanese campaign, they were assessed the $10,000 penalty, and they could have been assessed penalties for each one of their outstanding over the limit contributions, but the statutory limit is the $10,000 unless there are aggravating factors, which there weren't in the Albanese campaign, and there are not here in the Bashner campaign. And just in terms of Michael Bloomberg, he was a non-participant in the program, so he was allowed to contribute as much as he wished to his own campaign, just to point that out.
May I respond to that?
One second, before
Sure.
I forget. I'd like you to respond to one of Mr. Bashner's point, which I confess I'm a little uncertain about. You argued that the CFB staff was conflating your campaign with you personally, and that was an error. And I'm thinking to myself, suppose there had been no asset purchase agreement. So you've got this website, okay? So who really owns that website? I mean, I guess technically the campaign owns the website, but the campaign is you. And if you run for public advocate, or if you ran again for mayor in 2 years, and there was no asset purchase agreement, wouldn't you be free to use your own intellectual property, and that therefore the asset purchase agreement really conveyed nothing of value to you? I'm not being argumentative. That's a genuine question.
May I respond?
I'd like
Oh,
you
okay.
to address first, and then back to
Wonderful.
you.
Thank you.
Sure. The way that we treat assets such as a website from a prior cycle is if a campaign reuses a website in a future campaign, any alterations or any expenditures made in changing the website, in bringing it up to date with the new election cycle would have to be reported as expenditures and would be counted towards the expenditure limit, such as like maintaining the domain name, paying server fees, monthly server fees. So if the Bashner 2017 campaign is continuing to pay all of those fees, paying for the domain name to remain in existence, those would be transferred to the new committee in whatever election he chose to run in. But in terms of the intellectual property involved in creating a campaign website, those expenditures wouldn't be reported. And that's just how it works.
Right, but you're answering the question from the point of view of what's an expenditure. I'm really asking who's got the right to use it, and do you have any position on that, or do we have any precedent on that from the past?
On that, only in terms of the tangible payments, but in terms of just the website in existence, we look at it as that website has been used to its full value for that present campaign, and it has no more value for once the election is over.
Okay, I mean, that may be a valid argument, but it's a separate argument.
But ordinarily, that would work to the benefit of the candidate,
Yes.
Right.
because otherwise it would eat into that candidate's expenditure limit for the next campaign.
Right.
So you're thinking of it from that perspective.
Yeah, because all of the ideas of thinking about what the issues are and what color you want it to be, that transfers at no cost. I mean, that's what it is. And
Well, and that's my question
Yeah.
to Mr. Bashner, and you don't have to answer, but just think about this. If you do indeed run for office in the future and you contribute this website, are you going to show that as an in-kind contribution worth $33,000?
Yes.
And that would be over another contribution over the limit.
Unless,
New
of course, there were sufficiently different changes to it so that all of it were not used in the same way, in which case the value would not be $33,000. If, for example, I had a new website created and I migrated the content, we could distinguish between the value of the ongoing website and the migrated website. And I'm guessing that there'd be some allocation there. I could also sell it to the campaign rather than contribute it to the campaign and get my money back that way.
But come back to my question.
I would love to come back to your
isn't-
question.
My question is Bashner 2017 and Bashner, let's say 2021, they're both just you.
No, sir. If I may, I was sufficiently impressed by the campaign finance board that I must distinguish myself from my campaign and that they're two different things. And in fact, my accountant tells me that I have to file a tax return for the campaign, which is not me, which is the campaign. And in fact, when I have a bank account for the campaign, it can't be my own personal piggy bank. It's got to be a separate account with the campaign treasurer under scrupulous rules, because my money is not the campaign's money and the campaign's money is not my money.
Yeah, I get that. I get. But
Forgive me if I'm not expressing it well. I'm not
you're
familiar with
expressing it
campaign
perfectly
finance
right.
form.
My point, though, is that the question of legal identity always depends on context. And it may be for tax purposes and other purposes, you and your campaign are distinct. But if there had been no asset purchase agreement, and if you are now running for mayor in 2021, which is my hypothetical, and you decided, I'd like to use the material from the website that I created in 2017. In that limited context, the decision maker who decides whether you get to use the website from 2017 for the 2021 campaign is you. And so that would be true in the absence of a asset purchase agreement. So I'm not sure what conceivable value the asset purchase agreement conveys.
Well, again, since I am distinct from the campaign, and what's at issue here is my loan to the campaign, there were two parties, and there were two parties to that agreement, first of all. Second of all, to the extent that anything that I put out there is in the public domain, one might argue that anyone can use it for any purpose. But whether someone could use all of it together is a different question. For example, if someone wanted to do a documentary, if I wanted to sell it to someone, the making of, the mayoral race 2017, those would be distinct intellectual property assets, and people could only use snippets of those without my permission unless they were fully in the public domain. And now we're into intellectual property law, which is way above my pay grade because I'm a real estate lawyer. But I'm trying to help as much as I can.
I appreciate it. Thank you.
First I want to ask about the Albanese. We could have broken it up into a series of violations and penalized them more than $10,000. That is my recollection. Is that
That's
correct?
true, yes.
We elected not to. The way I'm hearing this is because even the date of the asset purchase agreement, as a technical matter, the violation had already occurred. And I think that basically what I'm hearing is that and a lot of equitable arguments as to what we should do in the face of it. I mean, that's sort of the way I'm looking at it. I don't know. You made, when I say technical arguments, but what I'm hearing is mostly looking at all of these facts, including that you didn't get any money, if you hadn't joined, and all the other circumstances, $9,000 is just a lot too much. Is that a fair statement?
That is a fair statement. I'd like to make one other point to respond to the date. I could have, and I fully intended, and I spoke to my campaign treasurer on the day of the election, and I said to him, we are going to buy the assets of the campaign. Now, on the day of the election, I was a little busy. And so that was one reason why I didn't do that. But the second reason was I did not want to empty the campaign's bank account on the day of the election. To me, that's a sleazy thing to do, to beat creditors and such. It seemed to me that I ought to keep the campaign bank account open and see if any other bills came in to pay them.
Maybe I'm missing something. How does that relate?
I couldn't come up with a price until I knew the exact cash balance of the account that I could repay myself. I did repay myself about $5,000 in loans, and I left $1,500 in cash on hand. And the response papers say I should be fined even on that $1,500. But you're correct. All of the arguments besides that are equitable.
But even the $1,500, that's an argument, in effect, what you call equitable or legal, that $1,500 ought to be sort of credited as if you had paid it back.
Yes.
And we would just say that as Mr. Bashner stated, he relied on that money in the account way past the date of the election to have it available to pay off any creditors, and that he derived the full benefit of that $1,500 past the date of the election.
Right, and that's a valid argument, but so is his argument that it was an honorable thing to do.
And in fact, there were no other bills because we were paid up and we ran a tight ship. And we did the best we could. For first-time candidates and a first-time treasurer, I think we did a good job. And, the other thing is, that we had the benefit of that over those months. Let's think about it. Let's say I emptied the bank account on the day of the election. Then what? If I had put more money in to pay debts because it's not right to stiff people, then that would have been an after-the-election contribution that I would have been fined on. So we're in the same place, Again, I understand that there is a technical violation if you don't buy the argument that I settled it in a commercially reasonable manner. Again, not commercially reasonable transaction, but commercially reasonable manner. And I'm certainly not telling CFB what to do, but if you could clarify this stuff in your rules for those of us who are first-time candidates, that would be lovely.
Fair enough. Any other questions from members of the board? Anything further from you all? All right, well, thank you very much. This was a very helpful discussion, and we're now going to go into deliberations. We're going to come back afterwards and announce our decision.
Thank you, sir. And thank you to the board for listening.
So, Mr. Bashner, you're welcome to wait for the board's decision, or someone will call you with the board's
Waiting's
decision.
better.
Okay.
I want to call my wife afterwards.
Okay.
Nice to see you.
Likewise. Under better circumstances would have been the case, but
Second.
All those in favor?
Aye.
Aye. Opposed? Abstentions? Motion carries. Secondly, candidate Richard Bashner, 2017 for mayor. The alleged violation, which the board proposes to find, is just one, accepting over-the-limit contributions. The board is recommending a penalty of $3,500. I'll move that finding and penalty. Is there a second?
Second.
All those in favor?
Aye.
Opposed? Abstentions? The motion carries. That is the end of our business for today. I therefore move that we go into executive session and then adjourn. We have no actual matters to vote on in executive session. Is there a second to my motion?
Second.
All those in favor?
Aye.
Aye. Opposed? Abstentions? Thank you all very much.
Would it be out of place for me to thank you?
You're always welcome.
Thank you.